hopefully.
Is Sheets fired?
There was an RO this morning,
Mm-hmm.
and Miss Sheets got parenting time for today.
Okay.
Wait, is today Wednesday? What is today?
It's Thursday.
Today's Thursday. If they need anything, they'll message me.
All right. Okay, so we're going to get on the record. Okay, and so we are on the record in Bong versus Department of Justice and others in 23 CV 45434. This is the time the court set for a status check on whether the parties were going to need a hearing on the facts of the case, if there were contested facts, or if the parties were able to, I guess, work out what facts could be stipulated. And so I guess maybe I need to find out what the status of that is.
Ms. White, would it be okay if I spoke to the court?
Sure.
Right.
Just go right ahead.
All right. So, Your Honor, let me just give a basic rundown of the background of the case. I sued Kate Brown and Rachel Banks in their official capacities as the former governor of Oregon and the then public health director of the Oregon Health Authority, as well as in their individual capacities for the vax mandate against K-12 employees, which resulted in the termination of my employment and denial of my vocation in the K-12 industry. The DOJ appeared in my federal case and asserted representation over Kate Brown and Rachel Banks in both capacities. For the purposes of capacities, Kate Brown in her official capacity as governor is basically the state. Rachel Banks in her official capacity as the public health director is basically the Oregon Health Authority, which is a state agency. And then Kate Brown and Rachel Banks in their individual capacities are just themselves. Initially, my reason for filing this suit was to challenge the DOJ's authority to represent Kate Brown and Rachel Banks in their individual capacities, which they asserted that they were doing so under the Oregon Tort Claims Act. And I assert that they cannot. This is not the federal case is not a tort claim suit, and they were acting outside of scope, and therefore the DOJ did not have authority to represent them in the individual capacities. However, as this case has gone on, there have been new developments that came to my attention, namely that when I filed a notice of subpoena to Ms. White, subpoenaing documents from the governor's office, the Oregon Health Authority, and the Department of Administrative Services. Ms. White, as well as Kate Brown, Ms. White objected and asserted representation for all those parties. And in that, she said that she asked me to inform her if I intended to serve those parties, indicating that she did not know if I'd actually served those parties or not, which indicates to me that there was no request by any state officer, board, or commission to appear in this case to assert those objections in this case, which is required under the powers and duties of the Attorney General, ORS 180.060. And with that, I think because we cannot stipulate that the DOJ does not have the request to defend Kate Brown or Rachel Banks from any state officer, board, or commission, that is the first prong, that they could not even appear, even if the Tort Claims Act applied. We're not able to stipulate on that fact, and also under the same ORS 180.060 subsection 1B, the DOJ or the Attorney General is also required by either the governor or the legislature to in order for the DOJ to appear for the state in a proceeding outside of the Supreme Court or Court of Appeals, they have to be required by the governor or the legislature to appear. It appears that they cannot appear. It is apparent to me that they cannot appear for the state without this request by the governor or legislature. So there are various points of factual contentions that we could not stipulate. Most
Okay.
importantly, that we need to find out if the DOJ has the request from the state officer, board, or commission, and as well as the governor or the legislature, which we cannot stipulate.
So my reading of 180.060 is very different from that. The statute there indicates that the Attorney General, it is mandatory that they appear for the state when required by the governor. It does not say they may not appear if that does not happen. There isn't a converse statement in there. That it does say they must appear when requested by any state officer in the discretion of the Attorney General. It doesn't say they may not appear if that request is not made. In fact, 180.060 in subsection 9 does give an explanation of when the Attorney General may not appear, and it is specifically without the consent of the officer, agency, department, or board or commission that's being represented. I don't see anything that would indicate that not requesting it would preclude them from doing it. Because just on the face of the statute, it appears that there are three possibilities. Either something is mandatory, or it is permissive, or it is forbidden. And looking at the statute, 1 is discussing when it is mandatory. And then 9 is discussing when it is forbidden. The other situation, if it is requested or not requested, appears to be permissive. And there isn't anything that I see that would require the request to be anything formal or in writing. Presumably, it would be requestable just with a phone call. So I'm not sure if that affects what you are trying to argue here. But the face of the statute seems to indicate that this wouldn't be something that could be argued. And it certainly isn't a matter of fact. It would be a matter of law. Actually, everything you brought up sounds like a matter of law.
Right. So I do see what you're saying, Your Honor. That said, we still need to find out if they have the requests from those those entities to represent Kate Brown or Rachel Banks in the individual capacity.
What do you mean? What do you mean if they have the request? What thing are you thinking would
Well,
be a request?
I'm thinking that they cannot appear without the consent of an officer, agency, or board
Yeah.
on behalf of Kate Brown or Rachel Banks in the individual capacity.
So you're saying that you suspect that the Attorney General appeared on behalf of these two individuals without their consent, went through, presume, some type of legal proceeding or a trial, and neither objected to the fact that they were being represented without their consent?
No, that's not what I'm saying, because they
Okay.
may have consented in the individual capacity, but in the individual capacity, they're not an officer, agency, board, or commission. So even if they consented, they had no power to consent, basically.
Okay. Well, I guess I would say is that it sounds like that still is a very legal argument rather than one where there is a dispute of fact. Because a dispute as to the interpretation of the law or the reading of the law would be an argument at law, not one of facts. I'm not hearing what the factual dispute would actually be.
So the factual dispute is that Miss White and I could not stipulate that they did not have the consent, or that the DOJ did not receive any consent from an officer, uh, board, or commission to represent Kate Brown and Rachel Banks. That would be basically it.
So you're saying that they did not consent to the representation?
They may have consented to it in their individual capacity, but that is irrelevant to DOJ representation because in their individual capacity, they don't have the power to consent and in the name of a board, commission, or
Right.
whatever the rest
So
are.
that sounds like an argument of law, though, not an argument of fact. What fact is different? I believe that Ms. White would say that they consented insofar as they were able to the representation. And you're saying you think they consented insofar as they were able to in the amount of in the course of representation, but you're saying that they are not permitted to do that anyway.
Correct.
So the not permitted to do that anyway would be a matter of law, not a matter of fact.
So can we just stipulate that that it was them that consented and not the state agencies and boards that consented?
Wait, no. Why would you say that the state agency did not consent?
Because they didn't, as far as I know.
So you think the state agency allowed the attorney general to represent it without consenting to it?
That is my belief, yes.
So the state agency objected at hearing?
It doesn't say they have to object.
Well, then on what basis would you assert that you have any reason to believe they didn't consent if there was no objection whatsoever? I mean, if I come into court with a lawyer and I sit there and my lawyer presents my case, or a lawyer presents my case, and I don't say anything about it, and I didn't consent to that lawyer's representation, it would be very odd if I didn't say anything at the time of that representation, wouldn't it be? If I didn't go, who is this? Why is this lawyer speaking for me? That would be an indication of.
However, the thing is that it's I'm saying that say Rachel Banks, for example, she may have consented in her individual capacity, but we don't know if the board or agency or department itself consented to it.
Were they not a party to the case?
In her official capacity, she was.
Right. Okay. And in her official capacity, did she say anything to indicate that the attorney general was not representing her?
I'm not aware of that, but regardless, she's not in her official capacity. She's not an officer, agency, department, or commission. She's just the head of a department.
That would be an officer, wouldn't it?
No, an officer, according to state law, is a judge or a DA. Case law, I'm sorry, not state law. Case law states that a state officer is a judge or a DA.
So I will confess I do not understand what your argument is, but I want to hear from Ms. White as well. So Ms. White, can you maybe help me out?
Yes, Your Honor, thank you. The first thing I want to say is that that none of this actually matters to the issue before the court as far as the claim. Regardless of if anybody consented, if nobody consented, it doesn't matter because in this state court proceeding, What the issue is, as I read it, is a request for declaratory or injunctive relief that the DOJ or the Attorney General can't represent an individual defendant in federal, like, well, in this case, it's a Section 1983 claim, but I suppose in other types of statutory federal claims. And so that's just a legal matter, kind of an interesting law school kind of way. And it wouldn't matter if DOJ or whatever did everything wrong or right in the federal case, because the question is purely legal. And so actually, to a certain extent, these stipulated facts don't even matter. We can just go as if we were in a summary judgment hearing right out of the pleadings on the face of it. It seemed like a stipulated facts would be good. And I thought at first, Ms. Bong and I were off to a good start, saying some stipulated facts to the effect of, the Attorney General often represents people in federal court proceedings and such. But what Ms. Bong wants to do is to add some other really more specific ones, which may or may not be true, but just don't matter. And that's where I started not wanting to go down that direction, because I just think it distracts. I don't even know if we need stipulated facts. It just doesn't matter. If you want me to have additional insight into whether or not how we represent agencies, I'm happy to give you that. I just don't think any of this is relevant to this particular case you have before you.
Okay.
Although I will say, just for the record, to my best of my knowledge and understanding, I have represented people appropriately in the federal case and in this case, the Bong case. But I just don't think it matters whether whether we did or not, because although I say we do, but it's not what the case is about. It's a legal question. Does the statutes allow for DOJ or the state to represent individuals, as we have done in the federal case?
Okay. And Ms. Bong, isn't that what you're trying to get at with this suit?
That was the second prong, yes, that they cannot represent Brown and Banks in their individual capacity, because I sued them for actions that they took outside of their discretionary
Okay.
functions, outside of the duties, which is outside of the definition of tort in the Tort Claims Act. And I did
Okay.
try to stipulate some issues with Ms. White that she did not want to stipulate, including some of the causes of action that I raised in the federal suit, just to give this court an idea of the claims that I have to show the court that it's not a tort claim, basically. It was for actions that they took.
All right. So there isn't any disagreement over what you sued over.
That doesn't seem to be, but Ms. White does not want to stipulate what I sued over. That's why I filed a motion for judicial notice, because I'm not trying to judicially notice the factual allegations, only that I made those allegations. So I believe the court can still judicially notice the causes of action that I filed against Kate Brown and Rachel Banks, even without the stipulated facts.
That's
Okay.
fine. I was just trying to make it simpler and shorter. From my point of view, these
Okay.
motions for judicial notice are unnecessary, because she could just attach a copy of what she filed in the federal case. But it's not that I disagree with,
Right. There's not a dispute over what was filed in the federal
No,
case.
right.
No
If
one's
she wants
saying,
to list
oh,
them all,
no, it
that's
was.
fine. Yeah, that's.
Okay. So it doesn't sound like there's a dispute of fact. I'm really not hearing a dispute of fact whatsoever. It sounds like there was a lawsuit in federal court. The Attorney General's office represented the parties that Ms. Bong sued, and that Ms. Bong is now filing a suit to essentially get a judgment saying that the Attorney General's office should not have, or must not in the future, represent people that are involved in that prior lawsuit. Like, the character of those parties is such that the Attorney General should not have represented them and should not represent them in the future. Is that other than what the people think the facts are?
That would be the basic basis of this lawsuit.
And it sounds like both parties agree that that's the facts of the case, that that's what factually happened.
Yes.
Correct.
And it's just, yeah, so
So
right.
I'm not sure what a contested hearing would get us in terms of additional facts or any contested facts. I don't think there are any relevant contested facts. But there is relevant contested law. Like people are disagreeing about what the law means in terms of what these facts should have resulted in.
I think that's right, Your Honor. And as far as I'm concerned, we can just do away with the stipulated facts and just rely on, the pleadings. Because I just don't think it matters. And I don't want to say I don't think it matters like in some kind of existential way.
No. I
it's
understood what you
necessary.
meant, that the facts are basically the facts in the pleadings are sufficient to make a determination, is what you're saying. Ms. Bong, does that sound correct to you, or do you want to throw something out there?
As long as I can put the base or the causes of action that I listed in my federal case without actually litigating, it trying to
Well, I
litigate
won't
it
be
in court.
considering them. To be fair, I won't be considering the merits of your
Right.
Initial federal case. However, what the filings were is something that there is going to be no disagreement about, because as you noticed, yeah, you could file the filings or the pleadings itself as part of your argument. And in effect, yeah, I guess I would be taking judicial notice of it in a sense, but they aren't secret. Nobody disputes what the lawsuit on your part was. Nobody's going to be disputing that you filed such a claim.
Okay, that was my concern because Ms. White did not seem to want to stipulate on what I filed in that suit. And the
Oh.
details may or may not be material in the final closing arguments, but I
Right.
wanted to make sure that they were stipulated because I didn't want any dispute at a later time, when we were done with our arguments that, this is,
And I would suggest that if what you submit as what you filed is in fact the exact thing you filed in federal court, I cannot imagine how Ms. White would dispute the factual basis of that was what you filed.
That's
Okay.
true. I wouldn't. I was just trying to make it shorter, but I think it might be easier just to not have stipulated facts. She can refer, maybe she shouldn't even have to attach the complaint because it is very long, like 200 pages. Maybe she could just refer the court to it and give the citation or something. And so that's what I recommend. But maybe we don't
Well, it
need
depends
to
on how
do
much
this.
paper you want to save, Ms. Bong. But it sounds like you can go ahead and submit the whole schmear and refer to it page by page if you like in your closing. But if you wanted to, yes, if as long as there was some way for the court to access it, it might not be necessary for you to print the whole thing out and submit it. But given that you can provide that filing for the court's reference, presuming you're going to be referring to it as, well, see, now this applies to that and that applies to the other. I don't think that there is a dispute of fact as to what you filed.
Okay. So I think probably the most economical thing to do would be for me to submit the docket sheet for the federal case as well as maybe the table of contents, and I think that should cover what I'm referring to in terms of what I filed in the federal case.
Okay, and that would make it like easy for me to find what it is you're talking about, like if you
It
say on page
should.
7 or whatever.
It
Okay.
should. And if I feel that there's another page in the filings that is relevant, I'll include it in the closing arguments.
Sure. And that seems reasonable. And I'm sure Ms. White, if there was something that came up where she's like, wait, that isn't what it says, then she could say that in her closing.
No, I should think so, Your Honor. And when you are able, are you not able to get onto Pacer and open cases and such?
Well, let me find out. I've never tried to do it before. Let's see.
Okay, well.
What's the website?
Well, the website, well, we call it Pacer. Let me see what it actually is. I should hope you would, because I mean, I think anybody can, but I think. Okay, well, let me tell you, here's what I click on, okay? So it's ECF.
Yes.
.ord.
ORD?
ORD, which Oregon District. I don't know what it stands for.
Oh, okay.
Okay, and ORD, wait just a second here. Let me get to the beginning. Okay, so it's ecf.ord.us courts, just like it.
Oh, .gov.
.gov, yes. And then you can,
Okay.
and then there's a slash. I don't know what happens when you type in that exactly.
I see there's Pacer Home. Is that what I'm after?
Probably. I have a link that kind of gets me in.
Let me see if
quicker.
I can get there. Oh, it's
I mean, I'm sure it's
thinking.
all public record. It shouldn't be,
Sure, and it requires me to log in. That's probably normal.
Yeah, let me see here, because
Need
it might be that we have a, a way to get in
Okay.
better.
Let me see.
Here.
I'm just seeing if it
And then if there's that.
user type.
Well, I feel like, I mean, of course, I don't exactly know because from my end, I'm like, have already logged in, but I think if you type
Yeah, that's
in query,
that's fair. I may need to set up my own account. It looks like I
you
need to
may
do
need
that,
to.
but it seems like something that I can do. In fact, actually, it's just it's filled in all my information for me. Give me just
Oh,
a
it must be,
second
yeah.
here.
And I feel like that would be a useful thing for judges to have, so I feel like somebody ought to be able to help you
Yeah.
with that.
Well, given that I have not had a case that spilled over from
Okay.
federal court before, I may not have had need to do it before. So, okay, and this is.
Well, let's hope that you can, and then you can just look at the docket sheet that Ms. Bong is going to send you to, or just look at the docket sheet yourself, once you have the case number, which I think is the complaint. And then you can see all the things without needing to have, this 200-page complaint and all the other long things.
Yeah.
Just,
I do, however, want to make sure I'm able to do it before I say we're all
Yes.
done and send everybody on their way.
Yes, for sure.
Okay. Really? Oh no, that's not right. Okay. Oh, that sent it to my. There we are. Oh no. Oh, well, I may have to work out. Oh no.
this is going to be something tricky, Your Honor, or something that's going to take a while, you can always just let us know if it worked out or if you need us to send you copies.
Yeah, I suppose. I was kind of hoping that it would just
Work.
take it.
Yeah. Well, that would be too obvious for the system to just do that.
Yeah. Yeah, I can let you know if it doesn't work out. At this point, though, it sounds like we can just go ahead with the closing arguments part. Is that right?
Your Honor, I'm still not quite satisfied with the subsection 9 without the consent of the officer, because it does indicate that there needs to be some kind of consent before the AG may appear in the action.
And
I don't believe they have that consent. Because it doesn't say objection, it says consent.
no, what
I
I
would
meant
argue
was
that I
that
just
they
don't see
didn't
why
have
it matters
consent.
for this
Certainly would
case.
sound like an objection. What?
I just don't see why that matters in this particular case, which is just challenging whether the Attorney General's office can represent people. So whether they're doing it right or not in the previous case is irrelevant.
In the previous case, it's irrelevant.
Oh, whatever we did in the federal
I
case,
didn't
which I
follow
think we
that.
did properly, but whether or not we did, that's irrelevant to this lawsuit, which has to do with whether there's legal authority for the DOJ to represent these individuals at all.
Yeah, but that's also the reason for my amended complaint, because I have reason to believe that there is no consent, or the AG did not get any consent from the agency or board.
Well, that's another matter. I would say that that would go an issue in the federal case itself as versus here, but I guess it's a separate issue.
Okay. Yeah, I'm not getting into Pacer. So let me
That's too bad.
move back to, yeah, I'll keep trying to work on it and see if we can figure it out. So I am not at all convinced that I understand what Ms. Bong's argument is, because it sounds like you're saying that the people who are being represented by the Attorney General don't consent to the representation by the Attorney General, and you're talking about in this very case here or in the federal case?
In the federal case, more importantly, but I'm saying that the AG did not obtain consent from the agency or the board of the, for example, Oregon Health Authority to represent Rachel Banks in either capacity, and therefore it cannot appear in that action in the federal case.
And on what basis are you making that assertion?
That's what we need to find out, because I have reason to believe that they do not have that based on the AG's actions of asserting representation on these entities in this case when I subpoenaed them.
What? I don't understand how a lawyer can represent you without your consent if you are aware of the case and present for it. I don't know how that is even remotely possible.
Well, they're not present for it, though. Now, she's present for Rachel Banks, who has consented, but Rachel Banks is not an officer, board, or agency in either capacity. They need consent from the board or agency before they can represent the OHA. Because it didn't say object to the representation, it says consent.
Sure. So they show up to court. OHA is aware it's being sued, right? I mean, you served them and everything. So they know they're being sued.
I served Rachel Banks. I don't know if the board is aware that they're being sued or not.
What? How? How is that possible?
Because Rachel
How
Banks
is
is
it
not the
possible
board.
that the board would be unaware that it was being sued if they were served? If you served OHA, who you were suing, right?
Right, I served Rachel Banks.
Right. Who is the agent or so of the board? Is that right? So they were served properly.
Correct. They were served properly, but they're not the
Okay.
Rachel Banks is not the agent. So I can serve the director of this a state agency according to ORCP 7, I believe. But Rachel
Fine.
Banks,
But at
even
that
though
point, we then say that the government agency is on notice that it's being sued because it's been served.
correct.
Okay, so they know they're being sued. Presumably, they know when their court appearances are. And regardless of whether they personally appear for or whoever shows up, if the attorney general is present representing them, how would it be possible for the attorney general to represent them without their consent if they are aware of the case? I don't understand how that would be remotely possible.
So you're saying that they are implicitly consenting to the DOJ's representation?
I guess. I mean, if you would consider that implicit, it seems pretty explicit to me. If I'm there, or at least I know the case is going on, and I know that there's a lawyer there doing my case for me, and I don't do anything to make it not happen, I guess that's implicit, but it sounds more explicit to me. And almost certainly, the attorney general became aware of the case by being notified by somebody.
I served
Somebody
the
told the attorney general.
I served the attorney general as well, so they knew
Okay.
directly.
Yeah.
But that
But
doesn't
I
give them
cannot.
consent from the board to represent the OHA. That's my interpretation
It
of the
is
law.
okay. It's just inconceivable to me that in any realistic way a group would be or that anyone would be represented by a lawyer in a case that they knew was going on without consenting to that lawyer appearing, without making some kind of objection to it if they knew that was happening and didn't consent. I'm just not picturing how that's possible.
Okay, so I guess we're assuming implicit consent that the agency implicitly consented to DOJ based on the fact that I served Rachel Banks.
Well, if you like, I would say that it's much more likely they explicitly consented and almost certainly made that request, but I don't know that. But I
Correct.
don't think it matters because the fact that they allowed it to happen without complaining about it sounds like consent to me. And since consent is apparently what's required in order for the attorney general under this statute to act in representing whoever the statute allows them to represent, that would get us there. That this statute doesn't help you. It doesn't really change things. Because there's no requirement in that statute that the request for representation be in writing or anything other than it could have been a phone call, which would leave very little in the way of a record. In fact, it could have been people passing each other in the cafeteria and someone asking. It wouldn't necessarily have to be formal in any sense at all. At least what I'm reading in the statute doesn't seem to require that.
I would agree with that. Yes. So by contentions, we would need to find out from the board of the OHA if they actually requested it and if they knew about it and consented to it. Because I'm sure the OHA gets sued a lot. And I'm going to assume that the board itself doesn't get the service. I don't know. I'm just guessing.
Yeah, that's what I'm worried about. I don't have any. It is inconceivable to me that such a thing could occur. But Ms. White, did you want to address that?
Yes.
Okay.
First of all, that gets back to my first point that whether or not the state properly or improperly represented anybody in the federal case has no bearing on the claim currently before the court, which is whether or not the statutes allow individual representations. Not talking about agencies, it's talking about individual representation. And if there was an issue that had to do with, somebody was not properly represented in the federal case, that would surely be a case for that federal court at that moment.
So Ms. Bong, you're only talking about the federal case, that they shouldn't have done this in the federal case because there was no consent?
For the purposes of my complaint, yes. But I mean,
okay.
we can also talk about the actions of the DOJ in this case in terms of representation, but that would expand the case to a little bit more than what even the amended complaint is. That they have asserted representation even without knowing, and that's just and this is also my point of contention. If the DOJ has appeared and appeared in this case representing, for example, the OHA who I subpoenaed without even knowing whether or not I actually served the subpoena, that would imply that the board didn't request or consent to DOJ representation, and the DOJ is just asserting representation. So, by that extrapolation, I'm extrapolating the DOJ's actions in this case to that case because to be honest, I don't know what happened in the federal case. But if the DOJ is representing, you know, non-parties in subpoenas without them even knowing that they have been subpoenaed, then what's going on in the federal case?
I don't know, but that doesn't sound like part of this.
And
That
Your Honor, I
doesn't
would
sound like
point out
part
that
of
this
the
case,
complaint.
sorry,
Yeah, go ahead.
this case, the actual defendants is the Oregon Department of Justice and the Oregon Attorney General. So
Yeah,
I
so
think this
there's
is a
no one
circular
being
argument.
represented.
Correct. However,
Okay.
when I subpoenaed the OHA, they asserted representation on OHA and in their objections to my subpoena because only the person who is subpoenaed can object. And the Attorney General appeared and said that they represent the OHA and are objecting on their behalf. So we can expand it to this case, but and then track back to the federal case. But I don't know, based on the actions of the DOJ in this case, whether or not the um, OHA's board actually is aware of the federal case and has consented to it. Do you get what I'm saying?
Okay. And yes, and in that case, I agree that it is not at all relevant to this matter. Because you're talking about the federal case, and that is not what this lawsuit is about. We're talking about an injunctive thing dealing with the attorney general themselves and their office, not their actual original clients.
Yes.
Okay. So we don't need to worry about that at this point because that would be, I guess I would say, a motion for another day type of thing, a complaint of a totally different sort that sounds like it would be a matter for the federal court, not this one,
I
because
have
the
to disagree
federal court
with
was the place where that occurred.
I have to disagree with that, Your Honor, because the DOJ and the AG's office are not parties to the federal case. This court has no in personam jurisdiction over it. It's a state issue. The court has no subject matter jurisdiction over the issue.
Okay. But all right. I'm not sure that changes anything though. Yeah.
So you're assuming that I'm asserting that the OHA is not aware of the AG's representation
Of it.
of it in the federal case based on based on its actions in this case, and therefore because it doesn't know that it is represented, it did not consent, and therefore the AG could not appear in the case.
But that's not what your complaint states. That's not at all. In your complaint, you're alleging that the attorney general can't do this thing as to those people in their individual capacity.
Yes, that's why I filed a motion for an amended complaint, Your Honor. This is based on new facts.
Well, except it's not though, is it?
Partially,
and also,
yes.
It sounds really, really different from what your original complaint is.
Yes, because it's based on new information. Because it's a two-pronged issue. When I first filed this case, I thought it was only the individual capacity issue. But when the DOJ asserted representation on the OHA in this case without them knowing, that gives rise to new facts for me to allege that the OHA did not consent, and therefore I've requested a motion for an
Except
amended pleading.
your opposing force, your other party in this case is not OHA.
No,
So how in the world do we get to where it matters at all whether OHA consents to anything, because they're not being represented in this case?
that's
It's the
because
Department of Justice and the Attorney General that you're suing, not
Correct.
OHA.
correct. So that brings me back to the federal case, because if like I say, if the DOJ is asserting that they are representing the OHA in this case without the OHA
But they're
knowing,
not, because they're not a party. OHA is not a party here.
No, but they are appearing in the proceeding on behalf of the OHA in terms of objecting to my subpoenas. So based on that, I'm extrapolating that they did not have consent to appear in my federal case, which I was not aware of at the time that I filed this lawsuit. Does that make sense? And that's why I have a motion for amended complaint. Did we lose the court?
Hello, Your Honor, or anybody in the court, or is anybody there?
I hear you, Miss White. Do you hear me?
I hear you, but what happened to our court?
It disappeared.
They did kind of, let's wait for them. I'm going to wait for them to come back because I still have this link.
Okay.
Well, let's just sit here quietly.
Back up to that.
Oh,
Okay,
Your Honor, are you
I'm
back?
sorry. Yeah, we got disconnected somehow. Apparently the timer went off. Okay.
Okay.
So Ms. White, can you, I don't know. I'm not sure what to address. The motion to amend sounds like it is entirely separate from what this originally was, and would be at best its own suit potentially, because it's bringing up an entirely different defendant.
Not quite, because it's just a supplemental pleading, and it's not so much that they claim representation of the OHA in this case, but rather that because they did, I'm asserting that the OHA may not have known or consented to their representation in the federal case. Does that make sense?
Well, I think I understand what you're saying, but I don't know why that would give you any reason to amend your pleadings in this case. I don't see how it gets you anything different in this case.
Because
OHA
if
is not
if the
defendant.
OHA did not know about it and did not consent, then the DOJ cannot appear in my federal case.
Okay.
The same thing applies to both cases. But in that case, the OHA is a party to the case. In the
And Your
federal
Honor,
case.
you want my thoughts, or, sorry.
Yeah, go ahead.
It's very hard to know when it's my turn to talk on these video things.
Yeah.
In my case, as far as I understand it, this legal case we currently have is purely legal. I think we should skip with the stipulated facts, and it doesn't matter, because it's just about this interesting legal issue. As far as the amended motion, which I guess I'll be filing a response to because it is a motion for leave to amend. But what Ms. Bong is proposing to add, as I read it, is to say that the Attorney General didn't do it correctly in the federal case as far as representation, and also to ask for injunctive relief, saying that we can't do so. I feel like that would be, as far as whatever we did or didn't do in the federal case itself. I believe that would be a matter for the federal court. I don't see how you could, with all respect, of course, how you would have authority to say that the Attorney General did something wrong in that federal case, and also as far as the injunctive relief in this case, I don't see how that would, I mean, injunctive relief telling the DOJ to follow the law seems kind of pointless, but if what she has said here is the law, which I am just glancing at it now, so I'm not 100% sure, but I definitely think you don't have the authority to, again, not an insult to you, but just how the system is set up, to say that DOJ or anybody did something wrong in the federal case itself. And so
Right.
I know it's actually a motion before you. I guess you'll have to decide it unless you want to just decide it now. But that's what I will say in my thing, saying that in my response, I would just say no. If DOJ did anything wrong, which we didn't, but if we did, the court here in state court doesn't have authority to address it.
I'll
Okay.
have to disagree because the state court is the only one who has subject matter jurisdiction of this state legal issue. It's not a federal issue; it's a state legal issue, and the federal court has no subject matter jurisdiction over it. The federal court is a court of limited
Well, here's
jurisdiction.
what we're going to do. You've made your motion. She's going to respond to it. And then I suppose you can respond to the response and I'll make a ruling on it. In the time being, because there's a timeline on that, for the time being, it's still, there really doesn't sound like there's a legal, a factual issue, but I guess we'll just set out a hearing and see if that develops, because if the court allows the amendment and then there is some kind of factual issue, then we'll still need our trial, I suppose. So let's go ahead and pick another date to come back on that. And we'll see if we still need trial. We're still set for the 26th of June.
Yeah, and Your Honor, just before we leave, my understanding is that as far as this little hearing we had today about stipulated facts, my takeaway from this, and tell me if you meant something else, was that we're just not going to worry about stipulated facts. We'll just address things on the pleadings or on the federal pleadings, and we just don't have to do that.
Yeah, barring any amendment to the pleadings, which would change it, I'm not hearing anything at all that would get me to where there are any facts in dispute that are relevant. So, Ms. Bong, if nothing changed about your complaint, that's still the case as far as you're concerned, correct?
Correct.
Okay. So we probably don't, well, all right. So we're going to leave our trial date on, but let's set a follow-up hearing to this to address, well,
How far out?
And
Actually-
I can write a response pretty quick, Your Honor, and I know unless something's different, Ms. Bong is always very prompt in writing responses, unless
Okay.
she can't this time.
in
but
that case,
can set it
maybe we don't need another hearing, because if the court allows the amendment will presumably be made, and then we'd need to set a hearing. But if the court did not allow the amendment, then at this point, we're already set for when y'all are going to have your closing arguments written and submitted. Is that right? You have dates on that?
I think so.
I think so. It's actually coming up close, so I'm concerned
Oh.
about when the court will rule on the amended.
Yeah.
Should we maybe
Okay.
say 3 weeks from the date of the ruling of whether it's amended?
What?
Or the amendment is granted?
Yeah, we could do that. Let me see here. When is the first thing due presently?
I think it was 2 months from our original hearing, which I think it's 2
Oh.
weeks from now, I believe,
Oh, that's too soon.
April
Okay.
8th or something.
And I will say, Your Honor, I do notice that I personally, there's a motion to compel out there too that I would
Yeah.
have to respond to. And so, and again, I can do these pretty quickly, but then you'll have to decide that too, I guess. And so I don't know if this messes up all the dates or not.
Yeah, I
It
think
probably
the
messes up
compel
all the
hinges
dates.
on the compel hinges on whether the complaint is amended or not. So if it's
Yeah.
not amended, then the compel is moot. If it is amended, then that might come into play at that time.
Well, why don't I could get my response to the motion to amend, say tomorrow, and then Ms. Bong, if you have the time, which I know you're a quick person, so if you were to respond to that pretty quickly, then maybe the court, of course, I know the judge has many complicated things too, but maybe we could just get the motion to amend done pretty quick, and then we can know if the motion to compel is important or not.
Yeah, but what I see is that Ms. Bong's closing statement is due May 7th, which is awful soon.
Oh, it is soon.
Yeah. We could simply change the dates a little. The due dates, because it's not like we're having court hearings on any of it. And given that we're not going to be having a full-fledged 2-day hearing on facts in late June, which is what we have scheduled, we could, set it out a little ways and not worry about getting it done before those dates, because I just don't see that happening.
Right.
I don't see any need for a lengthy trial. I don't know what the trial would get us, because it sounds like everybody agrees about what actually has happened for the most part. That said, what if we change our due dates? Put Ms. Bong's closing due, I don't know, how about last day of May?
That
Then
sounds fine.
that work? Yeah, that way there's plenty of time for everybody to get things done. And then state to respond by June 14th, 2 weeks later. And then Ms. Bong to have final say by the end of June, 28th June.
Okay. So we're saying that this is if the by motion to amend is denied, correct? Because if my motion
Okay,
to
then we're
amend
going
is
to have to
granted,
set a
that kind of
hearing. Yeah,
changes the case.
we would need to set a
Right.
hearing, and we'll just get in touch with the parties
Okay.
and set something as soon as we can. And hopefully it isn't that big of a deal.
Ms. Bong would be due on May 31st.
Yes.
And then my thing would be due on, I'm just checking the dates here, June 14th.
Yep.
Okay, which is Flag Day.
If you say so.
And then Ms. Bong's reply would be due
On the 28th.
All right. And then it would just take you however long it takes you to see if you could just decide it, or we could set a hearing or whatever needs to be done.
Yeah, I would anticipate, given that this is presuming that the amendment is not granted and that it proceeds as it is now, that I would not need a hearing, given that the arguments that the parties are going to make are going to have to be sufficient for the decision. So, yeah. I mean, unless there was some question about what you wrote, I wouldn't expect to have a hearing. I would presume that it would be clear enough and the court would make a decision based on its interpretation of the law.
Yes, I would assume so.
Okay. All right. So we will look forward to hearing from you. Oh, okay. And I'm going to have the stuff that you submit, the response to the motion to amend and compel, as well as the counter response, if there is one, routed directly to my queue. Would you please let the downstairs people know to do that? So that way I see it immediately and don't let it wither.
Do you want us to email it to your JA?
You could do that as well. I please do also e-file it.
Oh, no,
So
of
it's
course,
on
of
the
course. We
case.
e-file it, but sometimes
Yeah.
I know it takes a little while to process it.
Yeah, it's fine
So
if
we
you
just-
email it to the JA. If you have the JA's email address, it's going to get to me one way or the other anyway.
Okay,
Yeah.
who is your JA again?
Deanna Bulk,
Bolt?
Bolk.
B-O-L-K, Bulk, okay.
Yeah.
So we can do that, and I can just do those both at once, motion to amend, response to the motion to amend and motion to compel, and then, depending on how that works, then we can go from there.
Okay, so is it okay to insist that you have that in by the end of the month, the 30th?
To have the response to the motion to amend?
To whatever you're going to file.
Yeah, I think so, because the
response to.
30th, boy, isn't that coming along next week? But it
Next
shouldn't take
Tuesday.
very long. I mean, it's pretty straightforward. Let me just see when the end of the month is, though. When is the end of the month?
Tuesday.
Next Tuesday. Yeah, I can do that. April 30th, which is Tuesday.
Yeah. Okay, and Ms. Bong, would you be able to respond to whatever she put in by the end of that week, or do you want a little bit more time? I'd like to get this.
I should be
Yeah.
able to. So, Miss White's due date is, I'm sorry, what date was that?
April
30
30th.
April. So
April
it's this
3rd?
coming Tuesday.
Okay, and then I should be able to get it probably by Tuesday, April 7th, if need be. I don't foresee
Okay.
any real response needed. I did not
Okay.
add a lot to it, so I don't think Miss White needs to really respond to a lot of stuff. It's just additional injunctive relief request and a little bit of supplemental pleading to the original.
Right. So what I'll say is, if you don't respond, that's fine. But at the end of business on 7 May, I will consider it closed, and then I'll make the decision as of whatever I had by end of business on May 7th.
Understood.
That
Okay.
makes sense. Well, thank you, Your Honor, for being so flexible on this. I
Well,
hope
I'm
you
trying
can
to
get
be.
into
Okay.
the federal stuff. It's just interesting for its own sake. You can go poke around and see things, and I don't know.
Yeah, and I will let the parties know through my JA or somebody if there is an ongoing problem with me getting into the federal case. I was able to find the website, but it seems to be wanting money from me. So I'm guessing that it's something I need to take up with my TCA downstairs.
Yeah, I think it's pretty straightforward. I will tell you, Your Honor, that this motion to compel is related to a request for production that Ms. Bong has recently sent over, which we didn't actually even respond to yet, but, you know, we also said that we weren't, you know, that we were going to be objecting to it. So I suppose if you deny the motion to compel, that just probably makes the request for production go away. I would.
Yes,
Well,
and
that
it all hinges on
yeah,
the
I would imagine
amended
it's dealing with the
complaint
same
or
thing.
amending the complaint. So, like I
Right, it's
said,
all
if
together.
if the amended is denied, then the compel is moot, and we'll just move on to the original complaint closing arguments.
Yeah,
Yes,
and
that
I
all sounds
presume
good.
that if the motion to compel were not granted, like if I considered it first, if it were not granted, then it would make the amended complaint untenable, because you would need the discovery in order to pursue whatever it is you're asserting.
That would be correct. Yes.
Okay. All right. Fair enough.
All right. Well, this is all very good. Thank you, Your Honor, for taking the time to talk to
Okay.
us and being
Oh,
flexible.
not at all. So we have in your WebEx chat there, we've
Yeah?
sent you, what email was it, Ms. Bulks? We've sent you Ms. Bulks' email so that you can
Oh,
submit
yeah.
that directly through her.
Very good. I see that.
And I'll give her a heads up that may be coming, because she isn't used to necessarily getting that.
Okay, well, that's good. Well, of course, I mean, Ms. Bong and I have an agreement. We just serve each other by email also, so it'd be no trouble to also just serve your JA essentially.
Groovy. Okay, it sounds like we're all on track, and we will be hearing from you in the next week or two. And I'll get that decided as soon as humanly possible once those arrive. I see I have trials that week, but if I have to, I'll stay a little late and get it done.
Well, thank you,
Shouldn't
Your
be too
Honor. We
much.
appreciate your hard work.
Thank you, Your
Okay,
Honor.
no problem. Thank
Appreciate
you,
it.
everybody, and we will hear from you later.
All right. All right.
Okay.
Goodbye, all.
All right. Night.